My name is Andrea Reyes. I'm an immigration attorney here in Jacksonville, owner of Reyes Legal PLLC. We are an exclusive immigration law firm, and we dedicate ourselves exclusively to immigration. We handle all family-based immigration, waivers, asylum, humanitarian visas like visas for victims of crime, victims of human trafficking and domestic violence. And then, of course, we do deportation defense for individuals who are fighting their deportation case here in the U.S. It's been tough. These times have really forced us to reinvent ourselves, at least from a business standpoint. It's given us an opportunity, really. I mean, I think we have to find somewhat of a silver lining that we had to adapt to a new norm, and we were able to define what that new norm was going to look like. And so, my office already had some individuals that had kind of health complications and were more vulnerable populations for COVID-19. So we had already luckily started telecommuting for 3 of our members even before the stay-at-home order was issued. So we were able to kind of get ahead of it, and then eventually the majority of us ended up telecommuting. So it's been really challenging, receiving documents from clients and working with our clients that we love, that, face-to-face contact, that embrace, the hug, the hello, it's been really difficult and very, very strange, but we're managing. But also there's been just such a mess. We've had an influx of phone calls about all kinds of issues, individuals talking about unemployment, individuals asking about health insurance, individuals asking about their cases. So we've had, our phones have been ringing in terms of panic, a lot of panic. We hear a lot of panic from the community. And so we're trying to ease some of that panic by answering questions, doing Facebook Lives, and just being available to the community. I started doing immigration in 2014. It was a very different time period. And, 2017, everything changed dramatically and drastically. And we have just been dealing with change after change after change, attack after attack after attack on immigrants. And so, we've been dealing with this since, pretty much January of 2017. As you remember, the travel bans came out almost immediately after the Trump administration took the White Office. So right now, there's panic because of the executive order that Trump issued on April 22nd that talked about suspending immigration. And I know we're going to talk a little bit more in detail about that. There is panic because a lot of our clients, are immigrants, and a good amount of those immigrants are undocumented, so they don't have access to healthcare. They work in industries that are considered essential. They have which means that they have higher risk of COVID-19, the coronavirus, and therefore don't have access to medical care resources. And what's worse is also the IRS just recently confirmed that they're not going to be giving the stimulus checks to individuals who filed their taxes with their federal tax ID numbers, their ITIN numbers. So only individuals that file with Social Security numbers are going to be able to get those stimulus checks. So there's just a lot of uncertainty. There's been a lot of confusion, lack of access to information for those immigrants that did have a social and did have a job. They can't seem to successfully file their unemployment claims, and those that are filing are getting denied. I actually was sharing with you earlier, we've had some individuals reach out to us that for individuals that have not been able to pay their filing fees or could not pay for, a legal fee that they've offered to pay those services on their behalf. We've also had, that's us, like what we've seen here, but we've also seen just an influx in the community, reaching out, individuals who are donating their time and their resources. And we love to post those positive stories on our Facebook page, just because it's inspiring to see when when there are difficult times, how people come together, and it's really where you see humanity. It's really where you experience love, and it's really where you can see people being connected, like truly, authentically connected, is when individuals are going through a tough time. So, in our experience, that's been great to see. Yeah, so I mean, this is kind of where I was going off a little bit earlier. What we have seen a very big complaint on is access to reliable, consistent information regarding the stimulus check. In the beginning, the IRS wasn't very clear on who would and who would not receive a stimulus check. And like I said last week, it was very clear that certain individuals will not be getting their stimulus checks, including U.S. citizens. And then the other thing that we've seen a lot of is individuals who are filing for their unemployment are not getting, the website is constantly down. They're not getting access to it. They're not being able to actually finish the entire application because the system goes down. For individuals that are going to the offices, like they're not being seen, and those that are applying are not actually being approved. So there's a lot of confusion about who is eligible and who's not eligible, and that's one of the reasons why we are also doing a Facebook Live on May 4th at 2 p.m. on our Facebook page with our CPA, Veronica Brown. She's going to talk to us about all the specifics about unemployment as well as the stimulus check information. So the order, what does it say? What does it not say? It was a very broad order. It was issued on April 22nd. It's supposed to be valid for 60 days, which would mean June 22nd is when it's supposed to expire. However, they left it open as an option to re-examine it and if they need to extend it. So what does it do? Well, it's a suspension, but really it's a break. It's a 60-day kind of like a stop, a hold, a break. Immigration is not being canceled. It's just being suspended. It's being stopped. Okay. And I think that's a very big distinction that people need to understand. I mean, when Trump tweets Monday night that he's going to suspend all immigration into the United States, everyone goes into a panic. But of course, we wanted to make sure we had the right information before we gave that to the community. And that's it. It's a suspension. It's a stop. It's a break. Now, who it does not apply to, we'll go ahead and we'll give the good news first. So if you are inside the United States and you are considering, or you were already in the process of submitting your green card application, your adjustment of status application, you will not be affected by this because this order only applies to individuals that are applying for immigrant visas through the consulate, meaning from the consulate abroad. So if you have a family member that recently obtained their immigrant visa but has not yet traveled to the United States, they will not be affected by this because having obtained their visa, they are considered legal permanent residents and therefore they would be able to travel. So of course, U.S. citizens and legal permanent residents are not affected by this. The spouse and minor children of U.S. citizens will not be affected by this. If you are an investor, so there's a type of an investment visa called an EB-5. That's the one that everybody knows about. It's $1 million investment. So it could be actually either $500,000 to up to $1 million in an investment. Those individuals will not be affected by this because, of course, we want individuals coming to provide jobs to U.S. citizens and legal permanent residents. So they will not be affected. And it also does not apply to individuals to asylum and related protections such as special immigrant juveniles also. Now, non-immigrant, so again, this order affects immigrant visas. It's not supposed to affect non-immigrant visas like tourist visas, student visas, temporary worker visas, right? Non-immigrant visas are those that the individual does not have the intent to permanently reside inside the United States. So those visas are okay. They won't be affected. However, the order does say that they are going to revisit that in 30 days. So, basically they're leaving it as a future option to revisit and potentially pause it. And then, so who does it apply to? The actual individuals that it does apply, like this is where it kind of hurts. So again, only to consular process. So if you're here and your family member is abroad, it could affect them. It only applies to immigrant visas, not non-immigrant visas like tourists, F1 students, and temporary visas. It applies to employment-based immigration. So immigration, right there, you can be an individual that works in a foreign country, in your country, and are being petitioned by a company here in the United States, unless you fall under one of the exceptions for healthcare workers that's listed in the executive order. Then your case would be paused for 60 days. Diversity visas, right? We call the diversity of the lotto. That's going to be put on hold. And then some family-based cases are going to be affected. And this is where it really hurts these specific individuals. If you are a citizen here inside the United States and you petition for your parent, and you're in the consular process phase of that process, then your parent is going to be on hold for 60 days. And then for permanent residents, if you are a permanent resident here inside the United States and you petition for your spouse or your children, whether minor or old or over 21, those petitions are going to be put on hold. So essentially the order allows for U.S. citizens to continue processing for their families with the exception of parents, and all legal permanent residents cases are put on hold if they are in the consular processing phase. So yeah, and then of course there's like an exception for national interest if the individual can demonstrate that it's in the interest of the nation to allow them in. So that's kind of like a really compact, summary of the executive order. Short answer is maybe. It's all going to depend on the immigration process that the person needs, right? So again, if they're a U.S. citizen and they're not petitioning for a parent, they're good to go because this won't affect them. But what happens is when an individual is abroad, there has to be a two-step process. The first part is the petition that's done here inside the United States with USCIS. That's the Immigration and, oh my goodness, USCIS, Immigration, Citizenship and Immigration Services. I just got stuck. That's USCIS. They're the ones that are processing the petition. That petition, all it does is qualify your family member for a category. And it's based on that category that the person either applies for a green card or applies for an immigrant visa. So if you are just starting the process for a family member and they're abroad, go ahead and get started. That petition is going to take months to get approved, and definitely not 2 months, like more than 2 months to get approved. So go ahead and start that process. Now, if you're already in the petition, if your petition has already been approved, that's where this may affect you. If you're a U.S. citizen and you're petitioning a parent, or you're a legal permanent resident and you're petitioning for a family member. Does that make sense?
Now it makes sense, yes.
Yeah.
Okay,
so
good.
So don't lose faith. And there's also like for different phases, right? For different processes, there's different phases. So some of these phases will continue to be adjudicated. It's just that the interview at the consulate is not going to take place for 60 days because they give you, if you're approved, they give you your visa, they approve you for your visa at the consulate. So what's happening is they're going to hold the interviews for 60 days. Right, so I believe this individual is referring to the Visa Bulletin Board. It's under the National Visa Center, which is under the Department of State. This bulletin is issued every month, and what it does, those dates change on a monthly basis. And it shows which green card applications are going to move forward, and who's going to be able to be processed based on the date of the petition. So remember, I told you, right? When you do a family-based immigration, there's two steps. First is the petition, then is the green card application. And that green card application depends on where the applicant is. If they're here inside the United States and they're eligible, they can adjust status here in the United States. But if they're abroad, right, and they want to come in with a legal permanent residence, they have to apply for an immigrant visa. So both steps get you a green card. It's just a matter of how you actually get your residence, the process by which you get it. And the National Visa Center bulletin actually tells you when you will be processed based on the date on your petition, which is that first form, that first step. So again, that date will change constantly. But I think also there's a section to that question, because even though the NVC will, okay, so for example, look, I actually printed it out. This is what the NVC chart looks like, right? So it actually tells you right now, we'll go with India. Right now, if you are a U.S. citizen who petitioned for an unmarried son or daughter that's over 21, they're not married, by January 1st of 2014, that's when right now the NVC is processing that visa. So the date on here is the date on the petition. It's called a priority date. And then the date that the individual is going to be eligible for their visa is based on when USCIS notifies you. So there's something called final action dates and then dates for filing. And so it's a little bit confusing because you have the dates from the National Visa Center and then you have the dates for actually submitting your green card application. But there's a website that I'm actually going to send to you, Basma, so you can put in the chat. And that actually tells individuals when they can get ready to file for their green card if they're waiting for it abroad. Okay? And that comes directly from the USCIS website. Is a little tricky. I'm assuming that they are talking about citizenship and not for green card, but it really depends on whether the child is eligible for citizenship based on acquisition or if they derived citizenship. So, usually when a person is born inside the United States or born to U.S. citizen parents or became naturalized U.S. citizen, then they're clearly, a U.S. citizen. But you can actually, even if you were not born here in the United States or were not born a U.S. citizen, you can still potentially obtain citizenship if you were, again, born inside the United States or one of its territories like Puerto Rico, born to U.S. citizen parents, which is called acquisition, naturalized, meaning you were a legal permanent resident and then you naturalized to that of a citizen, like you and I both did, Basma. And then naturalization of one's parents. So if a parent naturalizes and you meet certain requirements, you might actually have derived citizenship. So as long as certain conditions happen before, for example, for derivative citizenship, the requirement says that the parent must have been a U.S. citizen, they must have been the biological child of a U.S. citizen, parent, they must be lawfully admitted to the United States and be in the physical and legal custody of that U.S. citizen parent. And all of this had to have happened before they turned 18. So back to the question, if the parent was deceased before the child turned 18 and not all of these requirements were completed, then that child will not be able to derive citizenship. But if all of these conditions happened before the child was 18, and let's say the parent dies when the child is 22, it doesn't matter that it won't affect the child's derivative application because they were able to demonstrate that all the requirements were satisfied before they turned 18. So I think that's where the question was going, and I hope I didn't go off on a tangent. It's going to depend on your process, right? It's going to depend on your personal circumstances. If you are established in your country and you are looking to immigrate to the United States, you don't want to rush it because you want to make sure your property sales and your business sales correctly in your home country. But if you're looking to study here in the United States and potentially get a job and get employed, then you might be looking to immigrate to the United States. So it's really going to depend on the process that you're looking for. There's no real answer to this. I will say, though, that for USCIS, the agency that's in charge of immigration applications here inside the United States is called USCIS. It's under the Department of Homeland Security. The majority of their applications require the applicant to demonstrate by a preponderance of the evidence that they are eligible for the relief they seek. Right? So in some cases, you'll have a heightened standard like clear and convincing evidence. But for the majority of it, you just have to demonstrate that there's a 51% chance that you are eligible for that relief. And again, some cases are going to be a higher standard. But the Department of State, on the other hand, has a lot more broader discretion in approving or denying visas. With a consular officer can look at a case and say, well, I have reason to believe that this applicant is going to be inadmissible, or I have reason to believe that this applicant committed misrepresentation. And with that reason to believe standard, they are able to single-handedly deny your application. And while there's no appeal process to a denied visa at the consulate, there is, there's other resources that you can reach out to, but it's a headache. I mean, it's a real problem, and not having an attorney represent you in that case would be really problematic, because it's just the mere contacts that you have to make after this kind of denial are extensive. So again, it really depends on the process that you're looking for, but within the agencies, the standard of evidence is different, and the way that applications are processed are different. So you just have to take that into account when you're thinking about, what it is that you're looking to do inside the United States. So if you are a Syrian, if you are a Syrian national who now has U.S. citizenship here inside the United States, and you want to petition a family member in Syria, then you are able to. The only thing is that in 2012, right, the U.S. Embassy in Damascus was shut down. So for individuals that are looking to do immigrant visas for Syrian family members, they have to go to the U.S. embassies in Amman, Jordan, Beirut, or Lebanon. Okay. Now, if they're looking just for like a tourist visa to come travel, they can apply at any U.S. embassy and consulate. So again, immigrant visas are very different than non-immigrant visas. If you're looking to immigrate permanently to the United States, that's going to be in Amman, Jordan, Beirut, and Lebanon, depending on what's closest to you. And usually, if, like, for example, let's say you're a Syrian and you're Syrian in Syria, and you have your legal permanent resident spouse who is a national of Jordan, you could actually go to Jordan just because of the mere fact that your husband or your spouse is a Jordan citizen. So, but yeah, you can still process. I mean, it's not an issue of processing. It's just a matter of finding the consulate that's going to be able to take your case. You just apply based on like your proximity, like what is okay. Yeah, and what's safest to you, right? Like, you also want to make sure that you're able to make it there without any issues. So the problem with applying, so if you were denied for asylum inside the United States, there is an agreement between Canada and Mexico and the U.S. about asylum seekers. So technically speaking, you have to apply for asylum in the country where you first basically reside in before you can apply for asylum in any other country. So for example, if you resided in Mexico, you should apply for asylum there before you can apply for asylum in the U.S. If same thing for like for Canada. So if you if you apply for asylum, if you lived inside the United States, you should apply for asylum first in the U.S. and then in Canada. But they do ask you whether or not you applied for asylum in any other country. So that's usually like a question that's part of the form. So it is possible, but again, it really depends on your circumstances. Now, I will tell you, Canada is fantastic for asylum. They actually provide attorneys for the individuals that are seeking refugee status through asylum. They actually provide, like a public defender here does for criminal cases, they actually provide lawyers for individuals seeking asylum in Canada. So if you have a basis to make it to Canada, then definitely apply there. Asylum law in the United States is very complicated right now. Okay, so again, I think it's not citizenship that they're asking. I think they're asking about whether or not they can immigrate through a green card process, through the immigrant visa. So the countries that are banned, there is a travel ban, obviously, but there is also waivers to that travel ban, and a lot of people don't really understand it. There was a presidential proclamation the 9645 and the 9883, those were, the travel bans that were subject to many legal challenges. The U.S. Supreme Court ended up ruling that it was legal, although we were not very happy to hear that. But there are actual waivers that you can apply for if you can demonstrate that you are an individual that has, so basically like your absence inside the United States is causing undue hardship to you or a family member here inside the United States, that the applicant's entry into the United States would be of national interest, so that we keep hearing that national interest. So for right now, for example, right now, individuals who are nurses, doctors, who are in the medical field, who are medical researchers, who maybe have worked in pandemic, situations in the past. These are individuals that right now to the U.S. are of national interest because their skill set is going to be beneficial, right, to the national interest of the United States. So those individuals could also apply for the waiver. And then, of course, that their entry wouldn't pose a threat to the U.S. Or the public safety of the U.S. So that is, of course, a very detailed process. It's called a waiver because you have to demonstrate all these things with documents. Now, whether or not they're successful is up for grabs. There are attorneys that specifically focus just on this because it's so specific. But yeah, So I don't want to discourage people from trying, because of course you never know what's going to happen at the consulate, but they are difficult to win. It's not, it's never a guarantee. And I mean, an attorney that tells you it's guaranteed or promised or sworn to you, they can't do that because again, that discretion that exists at the consulate, right? Reason to believe. And so a lot of these cases get put on hold for background checks, because they're doing background checks on the individual to see if they have any affiliations with, a terrorist or groups of interest. And so that's where a lot of these issues get stuck. But the question is, should we lose hope? No, I don't believe you should lose hope. I think you should be well informed, and I think you should do your research and be prepared to fight it with all you got. So once you are a legal permanent resident, right, once you have that residency, that lawful status, only an immigration judge can take it away. So like your green card expires, it doesn't mean you lost status. You find yourself in deportation proceedings, it doesn't mean you have lost your status yet. Now, it's called deportation proceedings because you have to defend yourself. So he got arrested because he has a crime conviction, and a crime conviction that apparently makes him deportable. In order for him to legally stay inside the United States, he has to present a defense. And so that defense can be, if it's an aggravated felony under immigration laws, he might have very limited options, because they call them aggravated felonies the kiss of death in immigration law. So I mean, he has to get that analyzed. He has to make sure that the criminal record is complete, right? Did the criminal attorney do everything that they needed to do to ensure that he, the plea that he took wasn't going to make him deportable? And then assuming that the conviction sticks, is there any legal argument to make that the conviction that he has does not meet the statutory definition of a aggravated felony in the U.S. under the immigration laws? So again, that's another niche of attorneys. There's something called crimmigration. It's the merger of criminal law and immigration law, because there is such a anytime that there is any type of criminal activity, there usually, it's usually followed by immigration consequences. So the interplay between those two laws is very important. And typically, and this is for your listeners, if and when a loved one is arrested or you're arrested and you are facing some sort of criminal conviction, and you are worried about your immigration status, and that includes legal permanent residence, right? You're not safe until you're a U.S. citizen, and even then, sometimes that could be questioned. But if you're a legal permanent resident, or you're here on DACA or TPS, or you just have a work authorization, or you're undocumented, you always have to be very careful on what you plead to on a criminal case, because that could affect you in the future for your immigration case. So typically, for example, we work very closely with a criminal attorney here. Her name is Belkis Plata, and she will she'll get a criminal case. She'll call us and say, hey, can we plead to this? I'll say yes or no. I'll write them a letter so she can turn that into the state attorney's office, immigration letter. And then based on that, the state attorney will, agree to lower the charge so that my client in the future, who's gonna face immigration consequences, is not going to find themselves deportable. So again, he's in deportation proceedings. He's not going to be ordered deport. He's not going to lose his status until a judge says so. So he has to fight his case in front of the judge until that judge says, okay, you're released, here's your green card back, or okay, this is an aggravated felony and you don't have a defense, and so now we're going to order you deported. I'm really excited that that there's been a lot of developments for COVID-19. I mean, I definitely don't think it's been enough. I think, Florida hasn't reached its peak yet. New York hasn't reached its peak yet. And so it's very worrisome that we just got the notification that Governor DeSantis is going to reopen the state of Florida for business, I think this Wednesday, April 29th. And so I'm just concerned. So our office is going to remain closed. We're doing that as a precautionary measure for our staff and for our clients. But we definitely encourage individuals to be conscientious and to be considerate of their neighbors, considerate of the elderly, considerate of those individuals that are more vulnerable and susceptible to COVID-19. I mean, what this pandemic taught us, and I think we agree on this, Bono, is that it's not so much about our health, but about what we care about our community, what we're willing to sacrifice for our community. And we just have to keep in mind that this is going to take some time. Again, Florida has not even peaked. The deaths, I think, in the state of Florida already reached, if I believe, we're at 1,191 deaths in the state of Florida, with almost 33,000 confirmed cases. So it's not pretty. And if we're not, if we don't continue practicing social distancing, if we don't continue being, considerate of one another, being kind to one another, then, we're going to see that second wave that everybody keeps talking about. Even Dr. Fauci talked about the second wave. So just be considerate, take precautions, keep up the cleaning, the Clorox, the Lysol, the disinfectant, the masks, the gloves, and of course, just be kind to each other during all of this.